5 seconds to go. Start. Sir, an important amendment has been brought in to section 143 of the Companies Act. The present act before amendment has made it mandatory for the auditors to report all frauds to the central government. Through this amendment, a threshold limit has been laid. Now, fraud up to a certain threshold limit only will be informed by the auditors to the central government, and frauds below the threshold limit will be reported to the company by the auditors and to the audit committee. Sir, I welcome the proposed amendment, but with a rider, because reporting of frauds, irrespective of the amount involved, to the central government would not serve any meaningful purpose. However, some aspects need to be looked into. 1. Reporting of frauds where key management personnel are involved is, by very nature, a serious thing and therefore should be reported to the central government irrespective of the amount involved. 2. The objective behind the provision could not be achieved unless an effective mechanism is evolved at the central government level to deal with the information on fraud received from the auditors of various companies. What is happening now and even earlier is this: as far as audit reports and CAG comments are concerned, the central government or the concerned ministry has to go through it and file their comments and lay them before both the houses. But I can say this from my experience that the central government is not looking into the various comments of the CAG and the auditors. By bringing this reporting provision, you should strengthen the mechanism to go through fraud and take action within the central government. The proposed amendment should also require to disclose details of frauds reported to the government that are more serious in the board's report. The board report should also contain whatever the auditor reported. Sir, the entire responsibility of detecting fraud has been given to the auditors. Auditing of a company is not a fraud detecting job. Now, in this bill, the entire responsibility of detecting the fraud or the major responsibility of detecting the fraud has been put on the auditors. The company management should also have this responsibility and they must be liable to improve their internal control system. The Institute of Chartered Accountants has already issued auditing standards, and the fraud reporting methodology is incorporated in those auditing standards. Sir, detecting the fraud has been left with the auditors, which responsibility must also be entrusted to the management or its various officers like the managing director, the chief financial advisor, the administrator, etc. Sir, the next amendment, which is important, is diluting the provision relating to loan to directors, that is, wholly owned subsidiaries, and the directors have been exempted. I do not know why that has to be done. It is related to loans to directors, that is, an amendment to section 185. Then there is proposed amendment to section 188. Provision for special resolution under section 188 should also be seen in similar context. Sir, SEBI continues to provide for the requirement of special resolution for material related party transactions. The requirement of special resolution in the situations envisaged under section 188 would have made companies more transparent and encourage shareholders' democracy in the governance of the corporates. it may still be appropriate to modify the clause to require the special resolution in case where related party transactions involve an amount above a certain threshold limit. In order to encourage transparency, explanatory statement as required to be given under rules to the shareholders should also state the criteria or the basis for the management for considering a particular related party transaction in the ordinary course of business and at arm's length. The SEBI requirements and provisions under companies law also differ on definition of related party transaction. While SEBI has aligned recently the criteria for material related party transaction, there are a number of differences on the corporate governance requirements as well. The government should evolve a mechanism so that SEBI and the company's law requirements coverage in regard to listed companies and companies with significant public interest. This would greatly help in easing business in India as well. Sir, the other amendments are consequential. I welcome some of the amendments and I request the government to look into the provisions of section 143 and the special resolution. With these few words, I support the bill and hope that the Honorable Minister will look into the suggestions and consider them seriously in the interest and benefit of the people of this country. Stop.